The first case is number 62. Counsel, do you want any rebuttal time?
Yes, Your Honor. 5 minutes, please.
5 minutes, fine. Okay, go ahead, proceed, counsel.
May it please the Court, Thomas D'Antonio for the appellant, the New School. This is a case, as the Court is aware, as to whether the Farragher-Ellerth defense, which is applicable under federal law and under the New York State executive law, has application to a claim brought under the New York City human rights law. I respectfully submit to the Court that the starting point for the discussion today should be this Court's prior decision in Forrest, whereas the Court is aware a claim arose under both the New York City human rights law as well as the New York State executive law. And while the Court disposed of the matter ultimately on a different ground, finding that there was no significant proof of a hostile work environment, footnote 10 of the Court's opinion indicated that had the issue been reached, Farragher-Ellerth would have applied to the claim.
Do we have the same statutory interpretation issue? Did we have the same kind of a statutory interpretation issue there, though?
Well, Your Honor, I respectfully submit yes. It was not briefed in the way that this issue has been briefed quite clearly. But in fact, the Court, as I pointed out in our brief, is always obliged to apply the law appropriately, and again, to suggest that that precedent doesn't have any validity because the parties may have chosen to focus on a different issue, I think is really of no moment. The Court said what it said.
What did the 2005 amendment do?
The 2005 amendment, Your Honor, I submit did nothing in terms of relevance to this case for two reasons. First, the 2005 amendment, or the Restoration Act as they call it, applies, we submit, to conduct that accrued after the effective date of that amendment, which was October 3rd of 2005. There's no dispute on this record that all of the relevant conduct ended prior to May of 2004 when plaintiff first came forward.
What do we do with the language in 8107 subdivision 13? That does seem to be more specific than the human rights.
Oh, I think...
Where it says the employer is liable and then it references specifically the supervisory or managerial.
I agree, Judge Graffio. I think there are...
No.
Yes, I think the language is different. Now, whether that difference is permissible is one issue, and I'll put that to the side for just a minute.
You mean whether it's preempted?
No, I don't think it's a preemption argument, Your Honor. I think it's an inconsistency argument. This Court has observed that there are two issues that arise when we're looking at a local law and its potential application when it's faced with contrary state authority. One is preemption, where the legislature indicates an intent to, I think the term is to occupy the field.
We don't really have that here, do we?
No, we don't, and we've never argued that we did.
Additionally, the New York City human rights statute has been more expansive than the state human rights statute, and we've given, full, we complied fully with the New York City human rights statute where appropriate.
Your Honor, I think the issue is whether or not the New York City Council has the authority when we get to the inconsistency argument.
Where is it inconsistent exactly? What's inconsistent about it? Is it just more than rather than being contrary to what the state does?
Well, no, Your Honor. I think it's inconsistent because what it does is it strips an employer of a defense, of any defense, when we're dealing with an act of a managerial and supervisory employee.
Couldn't it still apply in a mitigation context?
I'm sorry?
Couldn't it still apply in a mitigation context?
Not on the facts of this case, no, Your Honor, because, in fact, the mitigation provisions of subdivisions D and E have no application when the alleged harassment is a manager vis-a-vis a subordinate employee. It's only harassment of a subordinate employee of another subordinate employee.
Well, going back to what the Chief asked you, why can't the city be more stringent?
Well, I think it can't be more stringent when what it purports to do is to overrule the precedent of this Court that goes back a century and says that an employer can't be liable for the torts of an employee absent ratification, condemnation, approval. That's not just in the employment context. That's across the board.
Well, this is not a tort case. This is a human rights case. And
that's correct.
Violations of the city human rights law. It seems to me that Title VII and the State Human Rights Commission Act, that provides a floor, and that certainly the city can provide more rights.
I don't think so, Your Honor. Respectfully, I disagree. I think that this Court's precedent in a number of cases, like the Con Edison case, for example, suggests that you cannot strip away a right that's conferred under the law as a local legislative body.
So we would find this unconstitutional?
No, Your Honor. I don't think you need to find it unconstitutional. I think what you find it is invalid as under the Court's precedents that have existed for years.
What I envision the City Council trying to address is if you have let's say, any type of an organization that has many branches, let's say a drugstore, a grocery store, anything like that, plus you've got somebody who's a supervisor on the 3 to 11 shift, and there's no one there except this supervisor who's overseeing whatever's going on in the store or the factory or whatever. And they want to say, we're not going to let the corporation say, well, we had no idea that this was going on and therefore we cannot be held liable. They want to say, if you have a supervisor, you're responsible, and all of the stuff that you now want to use as a defense we'll look at in mitigation of what went on, but we want you to be responsible for your supervisors at any time. What's the flaw in that?
Well, Judge Piggott, with respect, I have two answers. First is, when you talk about arguing in mitigation, there is no availability in this context to argue in mitigation.
Either it is or it isn't.
Yeah, and frankly, it is. If there's proof of harassing conduct by anybody, this is the argument that the plaintiff makes in her preferred application. Now, we obviously disagree with that interpretation in the statute. That's in the briefs. But assuming that is the analysis that the Court undertakes, first, there is no available defense under that factual scenario. Secondly, in terms of employer liability, you get there under the traditional principles articulated by this Court and embraced by this Court, even in the human rights context. There are many cases that involve the embracement of the ratification and condonation standard under both the city and the state human rights law. In fact, the First Department's opinion in Dunn points that out, and Judge Littman, you were part of the unanimous panel in that case. But, Judge Piggott, to get back to your question, if, in fact, we have a situation where the corporation says, I'm going to put this person on a 3 to 11 shift. I think he's kind of a bad actor, but you know what we'll do? We'll just put him there. And we'll say, we didn't really have any notice of what he was doing. I think that a court could easily find an issue there to send to the jury on ratification or condonation. That's not this case. This case doesn't come anywhere close to that. In fact, this is a case where the plaintiff didn't do anything for 2 years. And when she came forward, the conduct immediately stopped. Immediately. And there's no allegation that didn't occur.
Well,
I'm sorry.
Well, why do you say this can't be used in mitigation in this case?
Under D&E, Your Honor, as I read the administrative code, that's not available to an employer who has where the claim is brought under subdivision 1 of 8107B.
Is that because it's strict liability?
Yes.
Is that
yes.
essentially your argument?
Yes. I think that the plaintiff's argument here is that on this record there be strict liability.
And I'm having trouble finding what you're talking about in the language of D&E.
Your Honor, I think that D makes reference to the availability of a defense for a claim under subdivision 3, and this claim would be under subdivision 1. I would note that in addition to the long-standing, I note that my time has expired.
Well, anyway, counsel, you'll have rebuttal time, all right?
Thank you, Your Honor.
You have 5 minutes. Okay, counsel, let's hear from you.
May it please the Court, my name is Jason Solitaroff. I'm the attorney for Dominika Zakrzewska, who is the plaintiff respondent in this case. Let me begin by responding to a couple of questions that Your Honors posed to my adversary. First of all, there is mitigation under subsection E, but it's only to damages. Subsection E says that if an employer complies with the factors that are set forth in D, then that's a...
You say that's true even if it's a supervisory employee?
It's crystal clear in the statute.
I understood him to say the opposite. You disagree.
Yeah, it's there. And what's... And one of the arguments that we made was that that's really a very clear indication that Fager-Ellerth can't be read into the statute. Otherwise, you'd have this...
Let me ask you, though.
Sure.
How do you frame mitigation? Let's assume you've got a plaintiff who, for however, whenever, whatever, is damaged. And she says, I'm damaged to the tune of $100,000 and I can prove it. And she puts in $100,000 worth of actual provable damages. Do you then say, well, that's all well and good, but we think over here we're going to mitigate that because we like the defendant, they did a nice job and everything else. So even though you're entitled to $100,000, we're going to give you 15.
No, the statute, again, is very specific. It only mitigates punitive damages and civil penalties. So the person, the plaintiff in your hypothetical, would receive their $100,000. However, if the plaintiff sought punitive damages as well, then the employer could come in and say, you know, we satisfy these criteria, we should not be responsible for punitive damages.
So mitigation is well, that's a very small mitigation.
Well, it depends. I mean, it could be a very large mitigation, too. You know, a lot of what you hear in these cases...
Can you be liable for punitive damages where you yourself are only vicariously liable, where you have no fault?
In a bad enough, under this statute, in a bad enough case, absolutely. If a supervisor is involved in egregious harassment, then the city law provides...
Without the slightest, even negligence on his supervisor's part.
Well, the wrongdoer here is a supervisor.
I understand.
So we're on the same page. And under that circumstance, yes, the employer can be liable. The city council made a choice here.
The school here took immediate steps. That correct? I mean, someone immediately spoke to this individual and
it depends on...
apparently told them you might lose your job if you do this again.
Well,
so why should they have this kind of strict liability?
Well, first of all, because the statute says that they do. And again, the city council made that decision. City council could have adopted a different standard, but they very clearly said that...
I guess the question is, why shouldn't they be able to avail themselves of the affirmative defense?
Because the statute doesn't have any room for it. Because if you read the Fager-Ellerth affirmative defense in there, you read out subsections D and E. Because how can you possibly have a defense to punitive damages if you're not even liable? Which is what would happen if you read Fager-Ellerth into the statute. And what would be even stranger is that the standards at D and E are more rigorous than the Fager-Ellerth standards in a couple of respects. For example, under D and E, an employer has to show a record of relatively few incidents of discriminatory conduct. That's not a requirement under Fager-Ellerth. So what you would have here, if you read Fager-Ellerth in, is a strange situation where an employer could prove a defense to liability that wouldn't be sufficient to prove a defense to punitive damages. And that's obviously backwards.
Well, but under D&E, you have to show any or all of the factors to get mitigation. So that presumably you could get mitigation without proving everything that's listed in subsection D.
Well, I suppose, except that I think the court would take, in terms of how, I think that'll be presented to a jury, and those would be the standards, and how many of them you satisfied would be.
I see your point, but it's theoretically possible, isn't it, to imagine a case where you don't have mitigation under, or where you do have mitigation under D&E, but you haven't satisfied Fager-Ellerth?
I don't believe so.
Because you only have to show one of the factors to have at least a chance at mitigation.
Well, but I guess that's true. The way I think trial judges would read that provision is to say that, is that Fager-Ellerth essentially requires an employer to take prophylactic measures. I think that's at the heart of the D&E defense. The D&E defense also includes other factors. But to answer your question, Judge Buffet, I mean, about the immediacy of the response, here, this case is a good example of why Fager and Ellerth doesn't always work to prevent discrimination. Because what we have here is while the new school did have policies, and while Judge Kaplan did find that the new school satisfied Fager-Ellerth, what we also had was a situation where the new school didn't bother to make sure that its employees underwent the quote-unquote mandatory sexual harassment training. And as a result, the individual defendant in this case, a supervisor, testified at his deposition that he thought it was okay to relentlessly pursue.
But even if he had undergone that, that wouldn't make any difference in this case, would it? You would still have this. Okay.
No, but, and, you know, it will be our view at trial if this goes our way, that the new school is not entitled to the D&E defense because they haven't met all the criteria.
So your theory of the case, or your theory of what the city council had in mind, was to impose strict liability in order to make them know they'd pay a price if they didn't make their supervisors take training and hew the line of the law in this area?
The city council made, you know, balanced interests and made a choice that the interests of the victim here would be paramount, and that if a victim suffered discrimination or harassment at work by a supervisor or manager, the employer would pay. That's the choice that they made. And again, you can tell that if you look at all the provisions of subsection 13, you see that they made a number of careful decisions.
How does it equate with the state statute?
The state statute is like Title VII.
What is the difference between the two?
The state statute, like Title VII, doesn't have any provisions on vicarious liability. It's an open book. And so this Court, I'm not sure if this Court has, but I know other courts have assumed that there is a Fagerell defense, the same way that the Supreme Court, in interpreting Title VII, felt that it had to craft something because Congress had it.
As I understand the state cases, you don't even have to, you may never even get to Fagerell because you can't win without showing actual fault by the supervisor. It's not an affirmative defense. I mean, not by the employer, not the supervisor, by the entity.
Well, there are certainly some of this Court's decisions that indicate that, yes.
Should we import tort theories here of vicarious liability?
No, because this is a statute which has, I mean, when the Court is engaged in a common law process of making law, it has to, it has to sort of impose its own judgments in some ways on what the appropriate standards of conduct should be. Here, the City Council has spoken. They've said what the standard of conduct is.
Why is this local law not inconsistent with the state law?
Because inconsistency is not something up in the air. It's not some philosophical concept that this Court uses to strike down laws that it feels are inconsistent with its own precedents. Inconsistency comes from a statute. It comes from the Municipal Home Rule Act. And it says very plainly in Section 10 of that law that localities cannot make laws that are inconsistent with a general law. Now, the new school here has jumped all over that and tried to use general law to mean anything. But general law is defined in the Self-Rule Act. Subsection 2.5 says a general law is a general statute that applies throughout the state.
So your view is it your view that this is just more stringent but not in conflict with? Is that how you view it conceptually?
Well, yes, and this Court has faced that issue.
It does make conduct unlawful in the city, which would be lawful outside. Why isn't that inconsistent?
Because this Court has held that the City Council was permitted under its police power lawmaking authority to protect its citizens more. If I go to a fast food restaurant, Judge Smith, in New York City, I see the calorie count. I don't see it when I go to a restaurant here in Albany, I don't believe. That's another example. The city can do more to protect its citizens than the state has. Let me just respond to one
argument. The citizens it's protecting are the employees, not the employers, correct?
Well, it's made that.
That's the purpose of
yes,
this
it's made that decision.
Anti-retaliation and sexual harassment statute.
Yes, that's right. There's one argument that we haven't reached yet, but is in the reply brief of the new school, although not its main brief, and in the employer amicus brief, which is that somehow this language in subsection B1 should be interpreted just to govern conduct within the scope of employment. And it's a novel theory, and I just want to make sure that I deal with it. And there's a reason why it hasn't been brought up anywhere before, either in the district court, Second Circuit, or in appellant's main brief. And it's because it just simply doesn't make sense. If you took that interpretation, what you would have is that the city law would not prohibit any kind of harassment, sexual harassment by a manager or supervisor, because sexual harassment is by definition outside the scope of one's employment. Now, Title VII, as interpreted by the Supreme Court, does prohibit manager or supervisory harassment, but just affords the affirmative defense. So if the court were to accept that argument, we'd have a situation where the city law all of a sudden would be, there's this floor or ceiling thing that the city wanted. Now, the city law would be essentially in the basement. It would be below the floor because the city law would provide less protection than either the state law or Title VII. Also, if you look at the next subsection, B2, you can see that that's managerial or supervisory responsibility means that the particular employee is acting as a supervisor generally, not in the specific conduct that gives rise to liability.
Counsel, anything else?
Not if there are no additional questions.
Okay. Thanks, Counsel. Rebuttal.
Thank you. I wanted to address a couple of points. First,
Let me ask you a question on the state versus the city.
yes.
We all agree that discrimination is illegal under the state law, right?
And under the city law and under federal law.
Yeah.
Yeah.
So why is it inconsistent that discrimination is illegal, and then here there's like, again, a more stringent standard that says it's basically vicarious liability? Why is it inconsistent?
Well, Your Honor, I think it's not the issue of whether discrimination is deemed to be unlawful. That's unlawful under every statute I'm
but it
aware of.
is, and now they're saying in this situation you have basically a vicarious liability. What's at variance?
The reason, what's at variance is that if I'm an employer in Albany or in Mineola
Right.
or in Buffalo, and I take reasonable steps under Farragut-Ellerth, or I don't ratify or condone the unlawful
Right.
conduct, I'm unaware of it, I have an absolute defense.
But city, as your adversary says, people who did business in the city do face some burdens that they don't face outside the city because the city council has home rule and can impose those burdens. Why not this one?
Because this one is, unlike the other cases where this issue has come up, this one is inconsistent. It takes away a right that an employer has everywhere else in the state.
Although the right was really a defense to liability.
Right, and a right to advance a defense that it can't
It
advance.
adds an additional burden.
Pardon?
It adds an additional burden
Well,
on the employer.
I submit it actually winds up being, there's nothing that an
Takes
employer
away,
can
as the
do.
judge just said, it takes away that defense, right?
Well, it
you
takes
can't
away-
have the defense. So in New York City, you have a different situation. Yeah?
Right, except it's also, and we point this out in our brief at some length, it's also absolutely inconsistent, we submit, with the purpose of the anti-discrimination laws, which, no matter whether it's federal, state, or local,
This is that discrimination is bad, right?
to eradicate discrimination, to
Yeah.
ensure that discrimination in
Yeah.
the workplace doesn't
That
occur.
discrimination is wrong, and we want to eliminate it. What is home
Right.
rule about? If they can't, again, put this additional burden that makes it even plainer towards the end that you say to eradicate it.
Because it doesn't eradicate. If you're in the plaintiff's position, actually, the perverse result is you can if your supervisor is doing things to you that you deem to be inappropriate, under Farragut-Ellerth, you come forward and the employer addresses the issue. Under ratification and condemnation, the employer needs to be aware of it and take steps to stop
You
it.
may be right that this is a terrible idea to deprive the employer of this defense and that the new school shouldn't be liable here. But if the city council disagreed with you, and looks from reading the code as that they did, why don't they have the right? Why isn't the whole point of home rule that some cities think one way works and other city thinks another way works?
Because we submit that there are limits on what a locality can do, and this court in Elliott and this court in Major Waverly says the same thing. You cannot, as a local entity, legislate any provision you wish. As the court points out, I think Judge Graffio, actually, you said there are some 1,600 plus municipal entities in New York State. If each of them were free to legislate as they deem appropriate, we would have chaos.
Wouldn't you have home rule, basically, if each of them could
As
do
long
that?
as, well, if home
I mean, again, what does home rule mean if you can't do this? I mean,
it means
you're
that
just, I think, and again, I'm just struggling with this, I think you're disagreeing with what they did.
but whether I agree or disagree, I'm saying that under the guise of home rule, a municipality isn't free to enact a law that basically overrules a century's worth of precedent from this court. I gave you some examples in the brief. What if the town of Brookhaven, where Grucci Fireworks was at, decides that we're not going to recognize a claim against an entity that uses dynamite? We're not going to hold that there's strict liability. You need to have some proof of negligence. Or if you have a municipality that's particularly concerned about drunk driving and says, we're going to impose social host liability, even though the Court of Appeals in D'Amico versus Christie said there is no social host liability. I submit that municipalities are not free to legislatively overrule what this court has declared to be the law of this state. That's why this court exists. I know my light's on.
Counsel, thank you both.
Thank you.
Appreciate it.